Get this.
Okay, everybody, we'll get started. This is a regular meeting of the Fairhaven Planning Board. Adequate notice of this meeting has been given pursuant to the provisions of the Open Public Meetings Act. At the time of the board reorganization in January of this past year, the board adopted its regular meeting schedule for the year. Notice of the schedule was sent to and published in the Asbury Park Press on January 6, 2024, and the Two River Times on February 1st, 2024. As well as supplemented by published notice of July 11th, 2024 to advise of the hybrid format. That notice was also posted on the bulletin board in Borough Hall and has remained continuously posted there as required by the statute. A copy of the notice is and has been available to the public and is on file in the office of the Borough Clerk. A copy of the notice has also been sent to such members of the public as have requested information in accordance with the statute. Adequate notice having been given, the board secretary is directed to include this statement in the minutes of this meeting. So why don't we start with a roll call?
Mr. Borough.
Here.
Bush.
Here.
Mrs. Scott. Mr. Newell.
Here.
Mr. Vella.
Here.
Mr. Ball.
Here.
Mr. Nika.
Here.
Mr. Anderson.
Here.
Mrs. Antonin. Mr. Bailey.
Here.
Mr. Fletcher.
So let's start with the pledge of allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We have no old business or new applications to hear. So we'll start with just the approval of the August meeting minutes. Those minutes were distributed by the board secretary before the meeting. Does anyone have any comments or concerns on those minutes?
No, I'll make an approval.
Second.
Mr. Newell.
Yes.
Mr. Vella.
Yes.
Mr. Ball.
Yes.
Bailey.
Yes.
For the record reflect, Mr. Fletcher is right.
Mr. Fletcher. Approve the minutes from.
Yes, again, yes.
Thanks.
Sure. Thank you.
That are we? So
Yeah,
we're carried. Okay,
yeah.
good. So so I'll set the table here. So we have we've started now over the last three meetings to talk about the master plan reexamination. Going through that discussion and hearing last month from Mike Sullivan at CCH, our board planner, we learned about the housing element part of the master plan has some time sensitive deadlines prior to when the full master plan reexamination is due. And so given that we have two separate, we have a housing element planner and a full board planner, we invited Mike Edwards, who handles the housing element part of the master plan, specifically the fair housing statutes that we're required to comply with. There's a deadline, as I said, June 2025. And so I know Mr. Edwards they've done work already on those requirements, and we're going to be briefed here tonight. I'd like to understand, I mean, for myself, we'd just like to understand, what the requirements are, what the progression has been. Has there been any public outreach, anything like that? What discussions have been had elsewhere for that for that element? So that's where we are, and then we can continue our discussion once Mr. Edwards is complete. We can hear from any members of the public or anybody on Zoom that wants to ask a question, and then we can continue our discussion from last month. Anything, Doug, anything to add to that?
I was asked earlier whether or not Mr. Edwards could appear by way of video conferencing. Since this really is not an application, since this is information based to bring us up to speed with that, I see no problem that I see that being distinctly different than holding a hearing or taking testimony in those kinds of things. We have discussed that in the past. So this will allow Mr. Edwards to come, update you on those materials. That's the only thing that I have to add.
Any comments from members of the board? Really, any other guidance we can give to Mr. Edwards in terms of what we'd like to hear about? All right, let's turn it over to Mike.
Okay, well, thank you, Mr. Chair, and thank you all for accommodating me and permitting me to practice on Zoom. Can you guys see me on camera or no?
No.
Doesn't seem to give me the option to. My camera's on. I guess that's okay. It's weird though. So yeah, I'd like to start kind of super high level and some introduction to the Mount Laurel Doctrine. I'm sure many of you on the board know very well what it is and its history, but I think contextually, it's kind of hard to understand where we're going if you don't understand the roots of the doctrine and what's changed as we move into what is quote unquote round 4. So obviously the landmark decisions were Mount Laurel 1 and Mount Laurel 2, Mount Laurel 1 being in 1975, Mount Laurel 2 being in 1983. Mount Laurel 1 said, towns, you can't use your power to zone to exclude low and moderate income households. But they didn't really put any teeth into it, and the towns that were ordered to not utilize their zoning power that way kind of did nothing about it. And then so it went back to the Supreme Court in 1983, and now they're all pissed off, and they decide Mount Laurel 2, which infamously created the builder's remedy and quotas. They refer to it as a fair share, but it's a quota that you need to comply with for affordable housing. So the theory was if you don't meet your quota, a developer could sue you under a builder's remedy theory. Because of the lucrative nature of the builder's remedy, obviously there were lawsuits filed throughout the state of New Jersey. It was kind of on fire, so much so that in less than 2 years, you had sweeping legislation adopted in 1985 called the Fair Housing Act. And kind of the intent and spirit of the Fair Housing Act was we're going to create the Council on Affordable Housing. We're going to create an agency solution. We're going to incentivize municipal compliance. And the incentive for municipal compliance was immunity from builder's remedy, kind of both during the deliberative and planning process while you submitted your plan and kind of bounced it around COA and objectors and all those types of things. And then to the extent your plan was approved on how you would meet your quota in any given round, you got substantive certification, or if you're before a court, a judgment of compliance and repose. So that was the theory, broad strokes. With the Fair Housing Act, COA functions properly in round 1. Which is 1987 to 1993. You'll notice it was then 6 years, and it kind of keeps growing after that in terms of the period of a round. Round 2, 1993 to 1999. So you got a new construction quota in round 1. You got a new construction quota in round 2. And let me just back up for 1 second. There's a rehabilitation component. I'm not going to spend any time talking about that because you guys have a 0-unit rehabilitation component, so I'm only going to focus on new construction. So you got new construction obligation in round 1, new construction obligation in round 2. That takes you all the way to 1999. In 2004, COA adopted regulations for round 3, which was then 1999 to what would have been 2014 in this first attempt in 2004. Fair Share Housing Center, advocacy group oriented around representing the interests of low and moderate income households, sues to invalidate those regulations and does so successfully in a 2007 appellate division decision. COA goes back at it and they adopt new regulations in 2008. Those are again invalidated, this time in a 2010 opinion. There's a bunch of stuff that goes on between 2010 and 2014, but ultimately COA tries for a third time to adopt valid regulations, but they gridlock 3-3 and nothing gets adopted. So in 2015, on motion to enforce litigants' rights from Fair Housing Center, the Supreme Court declares COA, the agency that had processed municipal plans, moribund and throws us all back to the courts. So that's 2015. Now it kind of starts to become specific to Fairhaven. You guys hadn't had any land to comply. Really, you've never had, since the inception of the doctrine, you really haven't had sufficient developable land to comply. There's a whole history of mission creep as it relates on how vacant land towns, or towns that lack vacant land, need to comply in terms of unmet need, or what you could redevelop effectively, even with your land constraints. And that mission creep really has gotten to a whole nother level as we approach what will be round 4 in 2025. But in any event, so round 3 is 1999 to 2025. The Supreme Court's decision is, in the latter third of that. And now we're thrown back into court. Fairhaven starts to, work on its plan a little late. We could have filed in 2015, but they started to work on it in 2017, 2018. They submit to the court. Ultimately, what you submitted to the court ended up being very close to what was your overall plan that the court approved. But there were some objections and interplay with M&M, a developer that you guys are familiar with, and he had an application before this board. And then Fair Housing Center, that same advocacy group that invalidated the regulations we spoke about in the 2000s. So ultimately, you reach a settlement with Fair Housing Center, and that forms the basis of your housing government fair share plan that this board adopted. I think that was in 21. So your settlement with fair share and your housing government fair share plan and your judgment of compliance and repose, which approves that housing government fair share plan, all sing the same song. Basically, they say, court, our cumulative obligation going all the way back to 1987 and going all the way forward to 2025 for new construction is 371. We have enough land, however, for 4 of those units. And that 4 is referred to as your realistic development potential, or RDP. And the 367 that are lost in that equation are referred to as unmet need. There's a significant legal distinction between them, and there's a tortured history, really. Unmet need isn't a term in the Fair Housing Act. That's the beginning of the mission creep. COA made that up in round 2. But just put that aside for a second. Relative to your 4-unit RDP, you have an obligation to create a realistic opportunity for the construction of those 4 units, which you've now done through M&M and Habitat for Humanity. As for 367, unmet need, in round 2 and really in round 3, the primary mechanism for addressing that was overlay zoning. You guys have, a lot of land overlaid as part of your round 3 housing government fair share plan. And you also did a mandatory set-aside ordinance, which said if there's any discretionary rezoning for multifamily, devariance for redevelopment plan, whatever the mechanism is for a density bump resulting in multifamily, you're compelled to capture a set-aside. In addition to that, you have an accessory apartment program where you permit accessory apartments that would be deed restricted in certain parts of town. So that's your round 3 housing government fair share plan. That brings us, I think, to round 4, which formally won't start until July of 2025, but there have been some deadlines in the new legislation that was adopted in the beginning of this year. So there are several iterations of that legislation. Our firm, vigorously opposed it for a lot of reasons, but one we'll talk about a bit tonight, I suppose. But ultimately, some concessions were given. Maybe they took that F legislation and they made it a D+ or a D- or whatever, but it's not a great piece of legislation. There was reason for the opposition. And we'll talk a little bit about the Montvale lawsuit, though I have to be careful in how I weigh in on that particular lawsuit. So in any event, the deadlines that have passed were primarily reporting requirements. The borough had to submit reporting information on its trust fund. And for those who might not know, you have a development fee ordinance. Well, you all know that. You have a development fee ordinance. That money's collected and put into a trust fund. That trust fund can only be spent as part of an approved spending plan. And the program, which we'll talk about in the DCA, now have reporting requirements where you have to provide information on that trust fund spending and collections. And then also you have to provide certain information on the affordable housing units that have been constructed in the borough. So those deadlines have passed. Your reports have been submitted. They have a new system for the input of that data. We couldn't quite get it. There's tons of bugs with it. They only unleashed it like a week ago, and it's been very troublesome and problematic. I would say 90% of municipalities were unable to utilize that system. So we'll eventually have to upload it on that. But for now, you're compliant with the plain language of the statute. So the next kind of significant deadline is let me back up. The new legislation does a lot of things, but it primarily abolishes COA formally, the Council on Affordable Housing, the agency we talked about, you know, from the 1980s, 90s, and, you know, moribund or defunct in the 2000s, early 2000s. And in lieu of COA, it charges the DCA with certain rulemaking functions, with coming up with quote unquote advisory calculations of your number, and kind of related tasks. And then it creates the program, which is supposed to be comprised of 3 to 7 retired judges. We now know who those judges are. And then there is some residual kind of court interplay here as well. It's poorly written, but there's kind of a strong implication that a municipality could circumvent the program and instead file a DJ action directly to court. I don't know that too many municipalities will do that because of the kind of cramped timeline associated with the program, and maybe having some judges with more intimate knowledge of the Mount Laurel Doctrine. I suspect most towns will go through the program process to the extent they're going to comply at all. And then, so there's the DCA, there's the program. The program's charged with effectively resolving disputes. Among other things, they're going to review and process your plan, hear objections to it, and try to resolve and kind of mediate disputes. So those are the 3 kind of pillars of the doctrine that replace COA, or 3 entities. As we said, 2 deadlines have passed: trust fund reporting and your compliance reporting. On 1020, the DCA, as one of its functions, is supposed to provide a calculation of your round 4 quota. They're relatively constrained in that calculation. The new legislation itself says you're going to take CO data in the state and by each individual region, of which are 6. You're going to take that household growth between the 2010 and 2020 census, and you're going to assume 40% of those households are LMI, and you're going to assume the same growth moving forward, and that's how we're going to calculate the number for the regional obligation. And then it really just becomes a question for the DCA of how you allocate the pie on on 3 factors: vacant land, jobs, and income are the 3 factors which dictate your allocation. So they're supposed to come up with a number on 1020. That number is advisory. I don't know exactly what that means, because I know that to the extent you deviate from that number, you're going to have sharp opposition seeking to strip your immunity. So I don't think it's so advisory in practice. But in any event, the borough will have to adopt a resolution committing to that or another number on or before January 31 of next year, so 2025. If there is no dispute to that number in the resolution, it will become your binding number on March 1, 2025. To the extent there is a dispute, it's supposed to be resolved between now and March 31, or between March 1 and March 31 of next year.
And that, I'm sorry, so that number gets added to the 4?
Yeah, okay, so we could stop on that quota for a second, because this is the substantive kind of deviation that most affects Fairhaven. So let's assume that no new parcels have become available, developable, approvable, and suitable for affordable housing. And so you're going to calculate your vacant land adjustment all over again at some point in 2025. It will be the kind of foundation of your document. So let's say that the DCA says your number is 100. You're going to say, well, thanks, DCA, I don't have any land still, so my RDP is 0. And then we're in a posture where we're talking about unmet need. And traditionally, there's been no real parameters. It's been extremely subjective as to what passes constitutional muster in terms of addressing unmet need. Where this really deviates, and was one of my main points of contention in Trenton, is this says, in that hypothetical I gave you where your number is 100 and your RDP is 0, it says you still need to create realistic zoning for 25. And I don't know what that means. So realistic opportunity is a term of art that basically means the density is sufficient to incentivize financially the production of the affordable housing. How you do that in an unmet need context, I don't really know. I will say this, I litigated a case in Moorestown where a developer came in on an unmet need site, an overlay site, and said, well, this doesn't pencil out. And I said, well, that's not relevant. We don't need to create a realistic opportunity for an unmet need site. Show me where that is anywhere in the corpus of the Mount Laurel Doctrine. And ultimately, I won that trial, even though that in that particular case, their expert opined that the rate of return was something like 1%. So so in that case, it was like 15 or 20 units to the acre that they still didn't feel like they had a sufficient incentive to knock down the building, redevelop, and provide the affordable housing. So in this setting, in my hypothetical where I say your number is 100, and we suspect it might be a little bit more than that, but let's just use that because the math is easy. The court is going to say you need to examine your mapping and try to create realistic zoning, really in the context of redevelopment, for 25 units. And if you were to try to achieve that in traditional inclusionary zoning, you're talking about something like 125 units to get that 100 and or to get that 25 units set aside. So there's a lot of debate ongoing about what that means. Does that mean capital R redevelopment? Do you have to have sufficient sites that meet the redevelopment statute criteria that you could address that? Because there is a provision that says or otherwise demonstrate why you can't do so. So what does that mean? So there are a lot of questions, but I think the way this plays out from a municipal perspective, and we're in the process of deliberating on these issues now and kind of trying to piece out where we're going to go, is we want to be in the posture where our RDP is whatever it is. I think it's going to be 0 or 1 or 2 or something very small. And I think realistically, as we look at the zoning map, there's not a tremendous amount of opportunity left in Fairhaven that we already haven't overlaid or addressed. One thing that, Fair Housing Center might say is, well, add density to your existing overlay zones. But I think that's problematic because we already maxed out those in terms of what we can accept from a sound planning perspective. So we need to deliberate on that as a subcommittee in the first instance and the governing body, and hopefully with as much collaboration from the planning board as we can. So we don't know exactly what the housing element and fair share plan is going to look like just yet. We don't know what our numbers are, but that's kind of the interplay between the DCA number and our form of adjustment in terms of vacant land. So and there's another component of the statute which is unclear, which is, do we, in that January 31, 2025 resolution where we commit to a number, do we say, okay, we accept your DCA number of 100, but we're entitled to a vacant land adjustment that yields an RDP of 0? They didn't say that prescriptively, and they did not say that. You would think, as someone who practices this, that that's not what they meant, that they meant, just the off the top number, and we'll deal with adjustments later. And I'll talk about that in a second as we get closer to some of these deadlines. So that's January 31, 25. That's your number is theoretically going to become calcified at some point in March 1 if there's no dispute, March 31 if there is a dispute. I find it very difficult to believe that the program is going to resolve all affordable housing disputes on the number in a month, but we'll see how that plays out. That's theoretically how the statute's written and how it's supposed to function.
Mike, we have somebody that has a question.
Sure.
Thank you.
Thanks. Just the whole premise of having space to develop. What happens when we have lots that are subdivided? Does that count as new buildable space?
I would say it depends on the nature of the subdivision. So it would have to be sufficiently large parcel that it could fit at least 5 multifamily housing units. So it has to be available, developable, approvable, suitable for affordable housing. And it really has to have a net acreage associated with it of at least 3/4 of an acre or so. So in that hypothetical, you would get at least 5 units and 1 affordable to generate any obligation.
Yeah, I think
It's a good question because
typical situation we have is we have some lots that are like 200 by 100 or 200 by 200, and they can now be divided into 100 by 100 or whatever 50 by 100. So I just was trying to understand if that new for every 1 lot that is today, it now becomes 2 lots in the future with 2 houses. Does that actually become buildable space that feeds into that equation?
In the examples you gave, no, they'd be too small to support at least 5 units in a multifamily setting without violating land use principles, particularly if they're in a single family zone. So I wouldn't be too worried about subdivisions that yield single family lots.
Earlier, you had mentioned accessory apartments. Could you give some more background on that? Like, for instance, if someone adds an apartment above a commercial building in our business district, would that then be part of the equation for fair housing?
Probably not, unless it's prescriptively in your settlement and in the zoning, because let's say if you guys granted a variance to permit an apartment, if it were it wouldn't be a variance where it's permitted, right? So if you just permitted it without requiring specifically that it's affirmatively marketed to the region's low and moderate income households, it wouldn't be creditworthy. So in order for it to be a creditworthy affordable unit, it needs to go, you can't just rent it out to your mom or your in-laws or whatever. You need to go for the region's kind of lottery process and affirmatively market to the region's low and moderate income households. It has to be deed restricted for a period of at least 10 years.
And that's even if it would be 1 or 2 apartments, or is that only if it's several apartments?
So it would depend, right? So if you if you permitted 5 apartments, you also have, in addition to your accessory apartment ordinance, right? You have a mandatory set aside ordinance. So if you had, in the hypothetical where there's a subdivision, you permitted, it was a single family zone, but you permitted 5 units, you're compelled to capture 1 affordable housing.
Right.
You can have 4 market rate and 1 would be
Okay.
deed restricted.
Okay, thank you.
Sure.
Going back to the single family zoning, you said that the first requirement is availability. Can you talk a little more? Is availability based on the fact like the land is for sale or owned by the town or something along those lines? How do you, if there's an open lot somewhere in town that's 1 acre, how does that become available? Is it simply that the owner sells it or chooses to let it be included in the affordable housing calculus, or is there
Effectively, that means
availability?
clear of title, but so vacant, and it has to be first vacant or redevelopable, then it has to be available, developable, suitable, and improvable for multifamily such that it would yield at least 1 unit. That's the criteria. So vacant or redevelopable, and then available. Available was at one point subjective. You'd reach out to the landowner and see if they were interested in multifamily. It became more objective as time moved on, and what that really means is clear of title. So no deed restrictions or easements or whatever that would preclude its use for affordable housing.
So a theoretical question, could somebody take a 1 acre property in the middle of range and build 5 units of affordable, or 5 units of housing with an affordable unit in that?
Yeah. So the whole idea of compliance is that you get to dictate where those things occur. So in the hypothetical where there's a 1 acre site, could they do it? They could if you permitted it.
What grounds, so, approvable, I mean, so does the fair, does this is not fair share, but does this override the zones, or what the density restrictions? I mean, I guess does this override density? So on Grange, I'm not sure exactly what the density, exactly what the density is, but I can assume that it could be subdivided in half, but not much more. Could they, in theory, do these rules override, and such that you could take that 1 acre lot, and ignore that density and build those units in that zone?
So right in the definition, I think what you're asking is, does your zoning factor into the definition of approvable? And the answer is no. A site may be approvable, although not currently zoned for low and moderate income housing. So the definition of approvable site means a site that may be developed for low and moderate income housing in a manner consistent with the rules and regulation of all agencies with jurisdiction over the site. A site may be approvable, although not currently zoned for low and moderate income housing.
Mike, it's what Mumford did in Rumson.
Yeah, the Mumford example.
Yeah, I mean, somebody comes in and under builder's remedy and forces the town to allow it to happen, but it presumes you have an RDP, right? It assumes that you have a need that you can't meet.
Right, that's why they got the builder's remedy.
Right.
And the town didn't have anything to go against it.
Right, but if you have that as a town, like, and we know our obligation is gonna be 1 or 2 units, better find a piece of land that you want developed. And
Mike, are you saying that our obligation may be 25 units? Is that what I'm thinking?
Your obligation is going to be, and this is all very poorly written, so we're going to fight a lot about this. I want to be measured in what I say in public. Your obligation is going to be your realistic development potential, whatever that number yields, plus you need to now create a quote unquote realistic zoning, whatever that means, for 25% of your unmet need. So in my hypothetical where I said your number was 100, and I'm really just making that number up. Like our proxy for you guys is 125. It could be 200. It could be 100. There's a lot of variability in how the DCA is going to allocate the pie. But just to make the math easy, let's assume 100. Let's assume nothing's changed. Your RDP is 0. No new sites have become available, developer approval, suitable and vacant or redevelopable. In that hypothetical, they're saying 25 units. You need to create realistic zoning for at least 25 units via redevelopment. It doesn't use capital R redevelopment, but there's an argument to be made there. Or otherwise demonstrate why you cannot do so.
But we said our unmet need was 367.
That's your cumulative unmet need for rounds 1, 2, and 3. This is 25% of your round 4 unmet need.
Okay, so nothing happens. We don't have to do anything with the unmet need from rounds 1, 2, and 3.
That's certainly our interpretation of it. I think it's the only credible interpretation of the statute.
So then it's dead. We don't have to do anything. Okay. And then
it's dead except we are going to get into this potential fight. So let's say that you had, and I know you guys don't have this kind of land, but let's just use this hypothetical. Let's say you had a 10-acre site that was overlaid at 10 units an acre. So that would yield, if it were to all redevelop, that would yield 20 affordable units, right? Because 10 acres times 10 units is 100, 20% of which is 20. And then you, as part of this realistic zoning obligation, said, well, you know what we're going to do? We're going to do a capital R redevelopment plan for that same site, and we're going to change it to 20 units an acre. And we're going to do a pilot at 10% or whatever. You know, that's the lowest statutory pilot. So we're really, really incentivizing that development. I would argue, and I'm going to argue, that in that situation, we've created realistic zoning for 40. Fair Housing Center is going to argue that no. You created realistic zoning for 20 because you need to deduct the round 3 overlay from that equation. So that would be the only kind of situation where I see it as your unmet need mechanisms for round 3 is relevant. But what we're talking about in terms of the 25% obligation is prospective in nature. So 25% of your round 4 unmet need.
So then 25, if that's what it turns out to be, we get added to the 4.
Effectively, yeah.
Okay.
And then there was like a lot.
We're actually hard required to have, call it 20.
But aren't the 4 already met? Weren't the 4 met through M&M and then Habitat for Humanity? So
yeah, you're done with the
So
4.
now we're talking clean
Yeah.
for round
So we're
4.
clean from the
Clean from round
367. We've got the 4 from M&M and
With the
Habitat.
exception of the one scenario that he
I think
mentioned.
you're going to find that the settlement that was reached before and the ordinance that you adopted, there was like 2021, 1, 2, 3, 4, 5, 6 through 10. And you created the opportunity to resolve those issues. You had your affordable housing zone, you amended the housing element in the fair share plan. That was all done in 2021. And I think that took care of, from what I'm hearing, your round 3. But it's not static. You're going to
So with the one caveat that unmet need doesn't ever go away. Like if your entire town, you know what I mean? Like it's there in the, but
You can't take it all tomorrow.
but yeah, but conceptually, I really think that you can think of round 3, round 1, 2, and 3 is dead. What we're really planning for now is whatever your new RDP is, 1, 2, 3, 4, 0. Plus 25% of your round 4 unmet need. That's what your housing element fair share plan is going to look like when we come back to you guys in June. And that was kind of the next part of this timeline.
And that, yeah, I'm sorry, just to make sure, and then that 25, let's call it for argument's sake, I know it's not real yet. The 25 then is addressed, like, in order to address them, we stay within those overlay zones, right? Like those 25 units would be developed based on the overlay zones that we've already established, correct?
No. Then I think that they would have to be distinct. They'd have to be distinct and new. You know, they could be distinct in a few ways. They could be redevelopment plans as opposed to overlays. They could be, and that's the hypothetical I was arguing about, you know, a minute ago that we're going to get in a fight about.
So then the overlay zones those overlay zones those are also gone with the 3 phases as well, with those.
They exist, but they showed the court how we
Right.
could theoretically meet.
If the property-
Okay,
If
so
the
now,
property-
so those overlay zones will not apply to what's going forward.
They won't help you for the 25%
Yeah.
kind of kicker unless you increase the density or do something unique and distinct about them, in which case we're gonna argue about net increase with Fair Housing Center.
Which is, we're gonna have to do that because there's
There's
no
no
other
spot.
place, I mean, you can't do it.
Commitment on the.
No,
This is all hypothetical based, we're not
Right.
getting to any.
Because the historic district and whatever, right,
Yeah.
that's the, they've.
But
all been-
I just want you guys to chew on this for a second, though. So let's say that we look at this and we genuinely look at our plan and we say within the context of sound land use principles, because you guys have traffic and, you know, there are new DEP regulations coming out every day on stormwater and flood zones and that type of thing. You might legitimately look at your map, and I'm not saying this is where it's going to go. This is all deliberative, but you might look at your map and say, well, we can't increase the density in those overlays without violating sound land use principles. And we have nowhere else to put it. So we're in the bucket of we can't comply with that 25%. So, you know, we may be there. I don't know. And you know, who knows how hard we're going to get into fights about what the criteria are to be able to be sufficient to demonstrate that you really can't meet that requirement. So there's a lot of ambiguity. I'm just trying to give you kind of the conceptual framework we're going to be operating under.
Mike, real quick, so if we get into a situation where we can meet the needs, and we have a plan in place and it's approved and we have overlays, somebody can't come into Hants and build 5 units on a 1 acre thing because it's not in our overlays, it's not part of our plan, correct? Whether it becomes available or not.
What they would do in that situation is that what they could do in that situation, and typically, like, you're not going to litigate over 5 units. You know, it's too expensive. But let's say that somebody did. They would come in and they would say, Judge, you know, we did this, like, let's say that we perfect our plan and we remain immune the entire time and we get round 4 approval. And then somebody comes in and says, or during that process says, I have this acre site, I could get 5 units on it, I could get 1 affordable unit. The town could, or the borough could, zone it for 5, of which 1 is affordable, or it could do that 1 unit somewhere else. It could do a group home, a 4-bedroom group home, and say, now we've not only met your number, we've exceeded it. So it might generate RDP because your RDP isn't stagnant, but that doesn't entitle them to a builder's remedy or site-specific relief.
Okay, nice.
The timeline again is on 10/20. You're saying October 20th of this year,
Well,
We get-
that's the pending calculation.
pending calculation comes out. And then between then and January 31st, the borough needs to adopt a resolution and then
On March, if you don't, right,
It gets adopted in March.
adopted March 1st or not March 31st.
that's fine, yeah.
Yeah, one way or the other from the DCA, or actually, I'm sorry, the program, you should have your number in March. And then from that point in March until June, you have the planning board will adopt a housing element fair share plan on or before June 30th of 25. And then you'll submit that, or the borough, and you will submit that. Really, in a perfect world, the planning board would adopt and the governing body would endorse prior to June 30th, and then we would submit the program. But it would be sufficient that the planning board adopted it and we submitted it. In any event, then would-be challengers get the opportunity to say, you know, your plan sucks, what about my site, whatever they need to say, on or before August 31 of 2025. And then there'll be a whole nother opening of dispute resolution. And we would have till December of next year, till the end of next year, basically, to respond to that objection or modify the plan to account for it. Then, you know, we fight about that in front of the program. They issue some kind of advisory opinion. We can make the tweaks that they suggest, or we risk losing immunity. And at some point, you know, in 26, in March, if we can't resolve our dispute by March of 26, March 15th, we can remove to court and fight it out in court. So that's the timeline.
So March 2026. So we would,
Can I ask another one?
yeah, I'm trying.
So if October 20th is when the quota calculation comes out, I know I checked our planning board meeting is October 15th next month. Would it make sense for us to have a meeting or move our meeting to digest that quota information? I mean, are we gonna know on the 20th, or is it like, you know,
That's, I don't think you can say it is a firm date, Mike, unless you tell me, I'm sorry.
Well,
Unless
so
you
I
tell
have,
me that it's not a firm date, that is what they're proposing at this point.
so we don't need to adjust our planning board calendar?
I think you'd want to wait till the number actually, until the calculation comes out.
And
I mean, well, I mean, I would, let's be guided by what Mike has to say.
well, so the number, it's actually prescriptive in the statute that it's on or before the 20th. There's no real penalty to DCA for not doing it, and I think it'd be foolish to assume that they're going to do. I suspect they will, but I wouldn't be shocked if they didn't. And in terms of the board and what it might mean for them, I'll leave it to your discretion as to how you want to handle it. I think typically how these things work is, you have a Mount Laurel subcommittee. They kind of come up with a proposal and what this might look like and what this might mean. And I like, and I'm not sure if that's the case in Fairhaven, but I like at least one planning board member on that subcommittee so that he can keep you all informed. I really just don't like the situation where the governing body, decides all these things and then dumps it on the planning board and says, adopt this plan. Like, I would like you guys to have some representation on that subcommittee to the extent you don't already. And to be fair, we haven't really met a ton because it's difficult to meet and deliberate without a number. So,
we have, so who is our, I mean, we have an elected one. I know we, meaning the board, hasn't appointed someone.
We don't have a moral subcommittee at the moment, do we?
We, not that I know of.
I don't think we-
Unless, but we have,
I don't think we did last time. I think we did.
I was not here for.
I think we did it as the entire board. We didn't have subcommittee to discuss this last
From
time.
what I
The
reviewed.
entire board and Todd went over this thing.
deliberated it over.
well,
like 2
Todd
meetings.
was on in the Mount Laurel subcommittee, and he was critical in those meetings.
Right, and then we discussed it in our planning board meetings.
Right.
So I mean, another big reason we wanted to hear from you today, Mike, I think this sort of gets to the heart of the matter really is as a board, given this timeline, what, I guess, where should we be interjecting ourselves or having these discussions with the appropriate people in the governing body, and when should those discussions take place, right? Like, I don't think it's productive to have like, we gotta let some of this stuff play out, I think, but at the same time, to your point, Mike, we can't just have and a draft of something put in front of us, a month before it's due.
Right,
Yeah.
Mike, is the council, is the governing body also discussing this in the same way with you as we have tonight? Should we be, and it's a shame that
Yes, he's not here.
Councilwoman Koch isn't here, to understand what work they've done. How far have you gotten with the council on this subject?
Well, so we've primarily worked in the context of the Mount Laurel subcommittee, and I believe we've only had one meeting. Maybe it was two. But I think that, and I don't want to describe what the substantive feedback from those meetings was at this juncture, but I would say that once the number comes out, we'll be meeting fairly regularly as a subcommittee, probably at least once a month. And I'd recommend that a planning board member be on that subcommittee.
Who is on the subcommittee now?
I don't know off the top of my head.
I know Chris York is here via Zoom. I don't know if he knows.
Yeah, and I don't know if it's a formal subcommittee or an informal, like some towns do resolutions appointing members and some are more kind of informal and floating. So I could get back to you on that.
Hi, Chris. He's on mute.
You ask him on mute. Can you ask him on mute? Is that the button?
Chris, it's Fred Roll. You're on mute if you're trying to speak.
All right, well, takeaway,
Well,
we should,
yeah.
we should have,
We gotta find out who's on the.
we gotta find out who's in the
Yeah.
subcommittee and we should nominate somebody. If there's gonna be, if it's not gonna be done within the planning board meetings, which I actually think it should be.
Yeah.
With a council representative as opposed to the other way around.
Exactly,
We need
which is
to-
the way I believe it was done this time.
Yeah.
And there was other subcommittee meetings that were happening unbeknownst to us, you know what I'm saying?
Yeah,
As far as we're concerned, as a board, we handled it.
yeah.
And then reported back to council and vice versa.
Right.
I didn't catch all of that,
Correct.
but I would say it's more typically, I mean, most of this happens at a borough level in terms of implementation. Because it is a zoning case primarily. You guys obviously are charged with the housing and fair share plan. It's very important. But in terms of deliberation, it is typically more oriented towards governing body.
Oh. What do you want to prove those?
Yeah, I mean, we'll just,
know when the next meeting is and you can decide.
yeah,
As available to communicate those meetings. Because I anticipate that once you do get a number, there will be increased frequency. Make sure you can make those subcommittee meetings. And then keep the board apprised.
so we'll find out who's on. And then we'll have to appoint somebody next meeting.
I think that would be great.
And that actually works out well, because that'll be 10:15. That'll be a week before the number of quotas out, and we can be ready to react.
And then, so when would we be, when would we have to, like, I wanna distill it back to our meeting schedule, when would we have to approve something, 10? Not
You guys
20.
would have till June 30th of next year to adopt a housing element and fair share plan. I would say, it's really crazy to me that you could have potentially a situation where you don't know if your number's resolved via dispute until March 31, and your experts are expected to draft a comprehensive housing element fair share plan and then get it before the board to be adopted on or before June 31. But that is the nature of the beast. So your next action isn't going to be until June. But that doesn't mean you shouldn't see drafts, as soon as they're readily available.
Okay, so this,
In a sense, that's the way it tracked when you had your 2021 ordinances. You may recall that we knew where we needed to be, settlement was there. We had a series of meetings and they resumed, if you recall, I don't remember that portion of it. New meetings to then change your master plan to adopt your affordable housing zone, your housing element, and those things that all occurred in 21.
Chris is saying he's trying to unmute, but he's not having any luck.
Okay.
But we can create a subcommittee.
What did he say? But we can,
He's
He said
unable
we
to
can
unmute.
create a subcommittee,
okay.
and he can answer via text if you'd like.
Well, I just think does that mean that
so we don't have a subcommittee.
Right. It's, well,
Okay.
it sounds like no time like the president, right? Yeah.
What do we need from
And we can resolve it.
So I mean, this has been super helpful. Does anyone have any further questions? I mean, this has been really great because it gives all the context I think that we needed. And then, and now we have a timeline as to when all this is happening. We know as board, we don't have a formal action to take until June 30th. And so we'll have to make sure we're seeing drafts of this before, so that when we're asked to approve it, it's more or less perfunctory at that last meeting. The other thing is that draft, is that something generally that we would solicit public feedback on? So I'm just trying to work backwards. No?
No.
Okay,
legal document?
okay.
Yeah.
Mike, is there anything else that we should be thinking about now as a planning board within the affordable housing conversation? It sounds like it's gonna start getting very active in the very near future from a prep standpoint. But other than making sure that we form a Mount Laurel subcommittee where there is and we nominate a planning board participant in that, is there something we should be doing in the next month or two?
Well, I mean, to a degree, you guys know the sites, better than the governing body. So, I gave you some of the loose criteria for when a site might be available, developable, approvable, suitable. You might want to start putting your thinking caps on and discussing those sites that you think are opportunities or that might be troublesome for you you should start discussing those sites with your appointed member when that member is appointed. But other than that, I would say just keep an eye out. Doug, you could reach out to me anytime you want, to the extent that you want to have an executive as we move along here, as it becomes more litigious and more deliberative. So however you guys want to do it, but just keep an eye out for these things and be mindful of it is what I would say.
And then one last question, if we approve, so obviously we will approve something on June 30th. Can that just be incorporated by reference then into the master plan reexamination? So then basically we've satisfied, since our master plan reexamination is due in 2026, we could does that satisfy the housing element part of the reexamination? I would think it would.
Unless there was something else that you.
Unless something came
Unless
up,
there was something
right.
else that you would do
Yeah.
just what we did last time.
So
Which was-
the adoption of the housing element fair share plan amends your master plan. So really, to Doug's point, you just kind of touch on that and piggyback on it and say, this is what we did just last year.
What we did, and then, so just, okay.
You would advertise for your public hearing in accordance with the timelines. You'd make sure that there were copies out to the county planning board, that there were copies out to the contiguous municipalities, just as you would with any of the other things that you did. But you would just be focusing at that point in time. You could treat it as I said before, you can always do a re-examination anytime you want, but you must do it at certain times.
Right.
This could be the re-examination just of your land use plan and housing element.
Yeah.
And then you would not readdress those a year later. You would just, as we said, reference that in your re-exam at that point.
Gotcha.
So it's already done, so we're not touching it again.
Okay.
Unless there were other issues in the land use element, housing that you wanted to deal with.
Yeah, it's like a section of the land use. It's
Yeah.
not-
It's
It's not the only thing.
usually your
No,
major
it's not.
one unless you have a zone change. Which is why that was done as the affordable housing zone at that point in time. You sort of did everything at once.
I don't have anything else for Mike, and so Mike, we thank you. Anyone else questions?
No.
Anyone from the public? Yeah, anyone from the public have questions? Great, well, thank you very much, Mike. I really appreciate you being able to brief us tonight. This was really helpful.
Well, thank you all for your time. Thank you for accommodating me. And honestly, thank you for taking an interest, because like I said, I mean, I think the best results end up coming when the boards and the governing bodies are talking and thinking about these things. So I do appreciate your time.
Excellent.
Be well, everybody.
Thank you.
Thank you.
You may find that going back to what we designated in the last plan, is that still viable? I know we had talked about potential plans, we looked at the church property, maybe in the future, if it came on.
Never got sold.
If it ever got sold, that presented an opportunity. I know we specifically, that resulted in some modifications to the Department of Public Works area where we arranged to have a portion of that go towards Habitat for Humanity as part of the settlement. Might look at that, because you do have to jump off, and I think probably what usually triggers things most in smaller municipalities like Fairhaven, it is the event that you had, not where, the gas station is not business. Suddenly here's an opportunity. And, it's when those types of things trigger. Unless you see someone suddenly putting lots of parcels together to do something, and then you can enforce your existing ordinances to say, okay, that's fine, you want to build, you have this property, you want to build a mixed commercial residential, wonderful. By the way, your affordable housing obligation is going to be, part of your approval, and will enter into a developer's agreement with you. Part of your approval process will be that of the units you have, some will be set aside for affordable housing, and then that will go into the administration of the borough.
So we should be looking for redevelopment area potential.
Well, I that's one way to handle it, sure. I mean, that's in a sense what you did. Remember the
We
element.
kind of did that.
What's available?
Right.
Vacant land is easy. Well,
We don't have that.
count the number of parcels that you have in vacant land and period. If it's not available, and this is something that I would suggest, and I don't take over the discussion, because many folks that know more about, there are things that are shifting. Your wetlands, your stormwater, your buffers, your barriers, they are changing. That may no longer be available. In some of these, when you take a look at some of these parcels, and I can't say I'm familiar with the church parcel, is there a portion of it now that may be wetland, so that where we thought we had a certain amount of acreage, that acreage is no longer available as a matter of law. You can't build there. So there's a lot of moving parts, and things change as you come along with different regulations. But you must be mindful when you do have a development that, someone's got to, all right, we're developing this, by the way, how are you complying with your affordable housing? Well, we're not planning, well, no, stop. We need to plan about it.
So I just want to ask a question. I don't want it to like go into a rabbit hole, but just everyone keeps referring to like the third act and the overlays. And so is that something you can explain relatively easily and quickly, or is that like a very detailed?
I think the best way to explain it easily is your unmet need is always in the air if there's an opportunity that presents itself. Say that number is 325. Right now, since there is no realistic way to meet that need, we've at least placed a plan in front of a court that said, if these things become available, it's viable that we can meet that need. But that need is always going to be there. But it's really not going to be a hammer on you until an opportunity of an available and realistic ability to fulfill that unmet need. The difficulty is, while that number's up there, this next round.
Does it call out specific parcels?
It does.
So like, am I assuming River Road, like any of those parcels?
So like,
It's a map with the fair share.
there's a map, yeah, the whole business district is considered part of it. There's a piece of the DPW was an overlay part of it. There's a piece of Fairfield Fields where that church property is a part of it. And again, the lady from the church came in here and was like, does that mean you're eminent domain? I mean, we said, no. We're just saying the church ever decides to sell the place and somebody decides to buy it and wants to do affordable housing, that's the area of town they can do it.
Well, like currently on River Road in the B1, B2, you're limited to one residential spot if you're doing mixed use. Is that change?
No,
That doesn't,
There's you have the affordable housing for myself, and I think, if I remember correctly, I think it's 20 units per acre in the B1, and I think certain parcels in B2 were 15 units per acre as the affordable overlay.
Do you have to have an acre or it's just a portion of that?
It's codified at lots that are 20,000 square feet and larger, if I remember correctly. So,
I don't disagree with anything he said.
right, and but however, remember, right, if a developer comes in and says, I want relief and I don't meet the 20,000 square feet and I want to, I want to utilize this site for a mixed use development and I want to contribute my 20% to your affordable obligation, right? That opportunity exists, right?
He wants to. So
He would argue that
he doesn't want to.
that he should get approval because this is an opportunity that's not.
To meet some of those requirements.
there's land in the overlay zone
Correct.
that if was to buy the property, can use that to, yeah.
So it's like if B1 said you can only put one residential unit there, but this overlay says you could put 5.
Yeah.
I could come in as a developer and say, I'm gonna put 5 because I'm gonna contribute to the, yeah.
And
But only in those overlay areas, not, not on back.
Was it interesting, because in the re-examination from last time, like that's a section that gets a lot of call out is that limitation in the business district.
which was taken care of at the last round, and that's what we're saying, like, as you look at this obligation, there aren't many available parcels, and by the way, I think there are only 1 or 2 parcels in the business district and maybe there are 3 that are north of 20,000 square feet. The vast majority of them are sub that, right, so,
Do we know why this Sunoco, I'm sorry, so, do we know why the Sunoco plan hasn't progressed? You seem to be in two of this. We were talking about that, like.
We don't, well, I don't.
I don't know either.
I hope
It's
to find
still
out.
green, right? Like there's, like, we have our solution for round three. Seems like the approvals were all there, we're all part of it, and they haven't acted. I even,
Well, they were waiting.
it was like the whole,
There
like,
was a county approval, which I thought had come through.
Yeah,
I remember they were
I was
using that as like
I think it
the storage site for all the sewage, the water
Go
main.
back, take a look when the last compliance review was done. Rich in coordination with they're probably looking at those as to where they were with their compliance of conditions. That's usually what you're reading.
Yeah.
We had a fairly voluminous resolution.
So you can see the.
But the outstanding was, one was, or we didn't ask him to resolve. Probably just pull that.
Something about like turning radius in and out of.
I Sheila may have it when it came in, we could probably just do a quick search on M and M and probably come up with. I'll try to get out to board members.
Yeah, that was the curb cut conversation.
Yeah.
That was the radius,
Yes,
but it was a county road, not our, we don't, or state road, we don't own the road.
Yeah.
So they had it. Perfect.
yeah, and they did though, I thought they did.
Fred thought they did,
I
yeah, he did too.
I
could've sworn
I
that was-
heard that, I heard they were green. Is.
So why they haven't pulled the trigger since then?
Month ago.
That's what I'm like, almost, if these guys are so hot to, develop property like this, I don't understand why they didn't act.
Retail space, maybe.
Rates, yeah.
So,
You mean for people,
Shouldn't call it.
they're gonna have a building with nobody
Yeah,
renting it.
exactly.
That could be an answer too.
Yeah, they wonder, because it's a lot of retail space, and
Yeah.
it has to be filled.
Sure, yeah.
so I wanted to, I guess, we left some time on the, well, actually, it's not even on the administrative items, so that's good. But, all kidding aside, I mean, what we wanted to do also tonight was to have a look at the reexamination plan and sort of create a scorecard as to what was done, what wasn't done, what areas we wanted to address, and then try and form, or at least start to form the different, staff in each area and who is gonna be in charge of it. I don't know that. I'm not ready to have that talk tonight. Kind of ran out of time on all those documents. If I'm happy to start talking about it, if people have done work or have questions or have elements they want to share from any of the research that they were able to do. But otherwise, I think maybe we just pick that conversation up next meeting.
I mean, I don't know what other work folks have done. I did kind of put some notes down ahead. I did read through it, just in advance of the conversation. I think, 2016 reexamination certainly addressed things like bike safety and the affordable housing. I thought we're at least round three. Obviously that's gonna, be reintroduced. It's funny enough, I had written down what are redevelopment areas according to state law. That's gonna be a redevelopment areas section. I feel like that was answered tonight by Mike, and that's actually really, I think it's good for us to kind of think about the example or the scenario where we are gonna have to come up with another plan if we have an unmet need that we need to try to claw through. So anyway, so I guess we think about that in the next month or so. There was a lot of talk in town about the trees. Obviously there's before the incident at Community Center Fields this past weekend, which is super scary. There was the tree preservation ordinance had been re-brought up at council, and I don't know where they got with that, but that was something that I was involved in a few years ago on Shade Tree Commission, where we had the borough attorney draft a new tree preservation ordinance that was, it was super detailed compared to what we have now. And it kind of got set aside and never really made it to the council chambers. There was some question of enforceability, I think. But anyway, so I do think that, like, as we're kind of going through this, it would be topical if we had maybe part of the survey, like what do the townspeople want the tree preservation ordinance to encapsulate? Is it more about, is it tree preservation? Is it hazard prevention? Is it the balance of the two? You know, can the borough help when, you know, tree removal is expensive for a private citizen, and is there some, I don't know, these are just things that are kind of going through my head on the trees. I wanted to open up for discussion. I don't know if anybody's familiar with about this, but liquor licenses in town, obviously it's based on population, but my understanding is that a lot of that changed at the beginning of this year, and I don't know what changed. And I bet you there's somebody in this room that does know more about it than I do. You're smirking, I feel like you got some insight, but what are the changes to the,
I don't know that it has been passed, so I'm not that up on it. But they were talking about opening it up significantly more broadly, similar to what happened to like the taxi cab medallions back in middle 2000s. I don't.
But there's major money to work out,
Major.
money. I mean, these are people's retirements.
Yeah.
On liquor license.
The same thing with the cab.
Same thing with the
They're
cab.
trading at $1.5 million and they're down.
And now they're not.
100 grand.
Right,
You know, 50
right.
grand.
The alcohol thing's the same
So,
thing.
yeah,
liquor license.
Yeah, same thing. I don't think they've changed yet. From what I understand, it has been looked into to see if the 2 liquor licenses that exist in this town are compliant, and evidently they're doing just enough to satisfy license law. If that, or, you know, if they do open up, it could have a interesting impact on it. The ability to have a viable, real
Restaurant.
yeah, so that is why I mentioned, I think.
How is that a master plan?
I think it's more, I'm actually thinking more about the survey of the town.
Okay,
yeah.
And like what people might prioritize for a master plan. And a lot of these master plan conversations seem to be wish list things. They don't necessarily have to be accomplished. They can be like kind of the topical ideas that the citizens are ruminating on. And I think that if that liquor license, if the rules do change, I bet you people in town would love to see more restaurants.
Oh,
yeah. And so I think, you know, right, like, so I don't know, some of it, I just wanted to mention these are
yeah,
whatever prep I did for this meeting.
yeah.
I just have a quick question. I missed the last meeting. So are we green lighting for sure another survey? Or are we still like kind of questioning it? And if so, when will that survey be offered to residents? So I was looking through the minutes. I could see some mention of it, but I think I was
So
reading too
the
fast.
first step is what we wanted to do or try and do tonight was, and what Mike Sullivan recommended we do was look through the reexamination in the context of the master plan. So that reexamination is reflective of what the town thought at the time it wanted to do, needed to do, and then go through each of the elements and decide what had been addressed, what had not been addressed, and then use that as a sort of starting point for what elements were going to, you know, what needed to be reexamined in this next window. And then that would get, that would then sort of inform the type of questions that would be in the survey, yeah.
Put this, which is sort of encapsulated by way of example. What you're going to see in your next round of reexamination report, at least with regard to affordable housing, is I think you're going to see mention of all those ordinances that we referenced before that came down in 2021.
Right.
To create those zones and those kinds of things, with a caveat that, and planning, for, round 4, which hopefully when we get to the final reason, will have been addressed earlier this year in 2025, and address then those ordinances we did once we had what our new number was and how we potentially are going to meet that in the future. So that'll be that section with regard to the housing element, land use, affordable housing. We pretty much have an outline for how that's going to be written in that reexamination report. And if we have adopted certain things as a result of the new number, referencing that and how the master plan was formally revised. So check that thing off on your list. And again, going back to the other things that you had, I think you will also see that there were references to the DPW.
Yeah, I mean, there's all sorts of stuff. I mean, 3/4 of the residents would use the parks more if they had more access to the Navigant River. since then, they bought the
We
property
bought-
down,
yeah, I know.
right, so.
Yeah.
Like you're saying, that's reviewing the last master reexamination, what do people want, what to be accomplished, what still needs to be accomplished?
Yeah.
And of what still needs to be accomplished, does it really still need to be accomplished, does everybody feel the same way about it, or they not feel the same way about it?
It goes back to that discussion we had earlier on when I said, there have been some law changes. These are the law changes that were at least referenced.
Yeah.
And these are that we already took care of that, the
Habitable square footage.
marijuana, those kinds of. It's like, okay, yeah, check it off. Don't worry about that.
Habitable
Yeah.
square footage.
You know, the buildings are defunct, well, we could say, well, this is being addressed, and this is being addressed, and addressed, we
Yeah.
move to the next thing.
Yeah,
I mean, some of these things, I don't know if they were, but I guess that would be the point of us all reading, like circular driveways. Regulations for safety concerns, circular driveways, I don't think an ordinance or anything is written into about circular driveways, right?
no, but,
And do we need it? I don't know, but I'm just saying, that's kind of the review of this that
and a
happens.
bunch of it was cured.
If
I
you-
think we have to figure out a way, so I thought it was interesting. And I don't know how you do it, but with these surveys, right, there were 500 and some odd people that responded in a town of however many thousand, right, 7,000, which I think,
That was 900 for the community survey,
got it, not,
the master plan. I don't know.
right, yeah.
Okay.
And if you look at the breakout, like, I think that. Right, a lot has happened since 2020, and there have been a tremendous amount of changes with. Our residents,
Mhm.
you know, and thereby, I'm sure some of the planning, like, if you look at the breakout of that survey. It was, and I don't remember offhand, I need to look at it again, but. It was something to the effect of 60 or 70 of the respondents had lived in Fairhaven more than 16 years. You know, then it was like 5% were there between 15 and 12 years or whatever.
Whatever
it was.
gets broken up a lot after that.
Yeah, and then it was really small after that, so I think that, you know. The new people who have come to town didn't have much of a voice in there, and perhaps it's access, right? Like, I know. I lived here. Then, I had no idea surveys were happening, right? So it. And I certainly would have,
Do you want the number? It was-
yeah,
So 45% lived in Fairhaven for 16 years or more.
right,
20% were residents for 5 years or less.
yeah. Which seems.
So
Not
it's not-
balanced to me, it's not as bad as I remembered it, right?
Yeah,
But
and
it
then
still
there's
seems off
another
balance, so.
20% were 6 to 10 years.
Yeah. Yeah,
So 40% 10 and under and
Yeah.
45% 15 and older.
yeah. I think we need more response.
Oh,
You know,
for sure.
I don't know how you
We'll-
get- I don't know
we
how
have,
you do
I think we probably have even more of an ability to go out loud on this,
Yeah.
right? So,
Yeah,
Social
I
media
guess
and
that's right,
everything,
yeah. So because I think that's gonna be important, right, to really understand what the community wants, what the residents want. So
It seems the only time you know what they don't want. is
Yeah,
when
no.
there's a variance
Yeah, exactly.
or for a
Yeah.
use or something like that. and
Yeah.
You get people out or. you get
Yeah.
Lots of people coming into the room.
Yeah, you hear very loudly when they don't want it, right?
And if,
I-
and if we based it on, a lot of it on like what was accumulated through 2016. I mean, the short answer is if you get to page 16 in the document. Like, all of those are done, the community facilities section, like check.
Majority of it, yeah.
Yeah,
And then, but when you get to open space, recreation, and you get to land use, I mean, it hasn't really been, I mean, with aside from, some of the.
I think it's.
Things we already talked
aside from what's been required
Uh,
by statute.
It hasn't been touched.
Yeah.
And I argue, as someone who's relatively knowledgeable of it, it's pretty hard to kind of put together all the land use bits with affordable housing being like planted right in the middle of it. So if we had any chance of drawing people in who are business or development oriented, I don't know how we would market it to them, because
They know.
it's so hard. They know it's hard.
they know it's hard, they know it's there also,
They
right?
know it's
People that
hard.
do that are very on the towns, but I do think. There are towns that signal their desire for somebody to come in and assist with their affordable obligations. And give some insight into, how you think that can be accomplished, but I will be willing to bet that. Almost all the local developers have been through all of our sites and they've determined that they don't pencil out. Whether it's density, land costs, coupled with construction costs and interest rates and all of it, but I think that is likely the challenge, because, you
The
know.
question is, so cool, and I think that knowledge.
Sure.
Knowledge of coming in, from what people are looking for, let's think of like the historic district as an example, then like. We should be a lot more smarter about how we ask questions and how we decide what is the right land use for that. If it is never going to be something that all those sites get built, bought up and consolidated and we do, town parking, then. What are we offering the homeowners or the business owners of those spaces now, all along River? So I mean, I think that, to me, that's the big glaring bit is, as you look through this, it's.
No.
It's.
We don't have a chamber.
We have some sort of business.
Yeah, it's an association of business.
No, that's just a loose group of.
Yeah.
of Business owners,
Yeah.
that's more social and a little bit organized, but. To me, that's just like, that's like my takeaway from looking at it, it's the land use. And it's the open spaces, we've invested a lot in our municipal built spaces, and we really haven't touched on how we're preserving our open spaces.
So Dave, you asked about the survey, but I think, I mean, if people have not looked at the results from the survey from 2019, it is a pretty interesting exercise, I think, to actually maybe go through and see what questions are still relevant. Because there's a lot of stuff that we can reuse, and then we'll figure out which ones we want to add. But I think a lot of, like, to your point about maybe shifting demographics here,
I agree with that.
yeah.
I
like
think from 19 to now, you're gonna get a lot of different
There's
answers.
gonna be a lot.
There's new people moving to my block with little kids. I got kids going to high school and in college.
Yeah.
Like the ages are changing on everybody around. So I assume these answers will be changing.
Yeah. And those, I don't know if anyone read through, like, all of the responses, the comments.
The 179
Oh my
pages.
God. I didn't make it through, I made it through a good amount of them before, I mean, some of them are just
Yeah,
pure
yes,
entertainment
yeah.
value were great, dying. Some of them were, some of them are good and
Smooth
thoughtful,
roads,
whatever.
pretty lines. I mean, it's.
Smooth roads,
Yeah.
pretty lines, that's right, that was up early,
Yes,
yeah, there were some that were
Important.
pretty good, yeah.
but again,
There were some of value in there, though, I
Yes.
couldn't make it through all of them, I got.
between reading these and the master plan of what we thought was a need,
Yeah.
you can kind of go through, check off what we did, what might still be a need based on this, do a new survey and kind of mash them together and say, here's the 10 things we think.
I think if I was mindful of question 9, prior to the Dunkin' Donuts application, are you in favor of allowing drive-through uses
Yeah.
in business districts? Where 62.23%, which represented 346 people, said, no, I could have guessed that the hearings were gonna go that.
Yes.
I think that would still be a good question to ask. Most buildings in the business, question 10, most buildings in the district contain a single use. Would you be comfortable with mixed use buildings? And I think largely on those people said,
Yes,
yeah,
yes.
we did do
Yeah.
some development for those
Yeah.
things. And again, 62.70% representing 348, we're saying yes. So I think you were on track for those kinds of things. It might, I think, and I'm pretty sure there was a question in there, what businesses do you want to see attracted here? I think that's always a question that you want, because things change.
A new one's
I mean,
coming.
20 years ago, somebody said blockbuster. Well, not so much now. Different things that you're gonna see, and I think that will inform the decision. I agree that if you go through your last survey, each of you highlight what you think are still viable questions, good questions to go through.
so to Doug's point, look, like, I think, guys, looking at Fred's timeline here, which I think actually was a lot of work, so good job doing this. But I do think the next meeting is begin construction of draft survey. Why don't we all, as a takeaway, take a look at the old survey and just check the ones that we should keep into the next survey, the things that are gonna have, answers that inform what.
You think we need to look at the last master plan reexamination? Because we don't want to check.
Checking those.
I don't know, if we need to be asking questions that we've already solved, we're just. busy-
No, yeah, that's like,
Questions.
like one page you could fully cross
I
out,
think
like next
probably
page,
that
like you
whole-
might find one that you think is still
We
relevant.
probably have to look at these at the same time.
Yeah.
Yeah, I think the 2060
One
master
doesn't
plan
form the
is
other.
important.
Yeah.
And it's pretty quick to read.
The master plan's no
Yeah,
problem.
pretty quick to get.
And this
That's-
is entertaining, actually,
Yeah.
if you get some
I
of these.
I kept having to step away from it, I was in and out of it,
Yeah.
but there were some where I was like, that was a
Right,
more thoughtful response than I thought you would get.
otherwise we're just like, it's ugly or
Yeah,
whatever.
yeah,
Right, that's not really helping us. No, that's here.
What was it? Worst pizza, I think, somebody said it was worst pizza, like, whatever, like.
Thanks.
You know,
Yeah. So Clark Catton hits, if you haven't had a chance to look at the Princeton master plan, also done by CCH, really comprehensive. I didn't get more than 10 pages into it, but it like started off great. I thought it was really set
Did
the.
we get this sent to us? That was
Yes,
it?
yeah,
We did.
it's only,
Sheila
yeah,
sent it, I think.
Okay, so I must have, is that the only master?
Sheila, the email.
Email with all the.
Super comprehensive.
Asbury Park was in there,
Okay.
Asbury Park master.
So I
plan.
gotta look.
Was the survey, the surveys were in there as well, or no? No, the surveys were
Those
in there.
I may have sent previously.
I know there's a couple of these now, I don't remember seeing the master plan, I'll
I
look at
want to read,
Yeah, so,
pepper you with things.
Princeton's master plan was in there, Asbury's master plan was in there, and our 16 re-examination was in there, and then
it. Okay.
there was the shade tree commission stuff was in
yeah,
there. I think,
Rutgers
too,
stuff.
and then,
Alright, so I got plans, so the master,
Yeah.
the master plan, I'll check it.
Thank you, Sheila, for putting it all.
yeah, thank you, Sheila.
All right, well,
Anybody else have anything else? I'll move to.
Open the public one more time.
oh, yes, open, any public comment one more time
Yeah, in September.
before we close?
No, thank you.
Oh, come on, something?
Great, I'll move to close.
Second.
Thank you.
All in favor? Alright.
All in favor? All opposed?
51.
Thank you, everyone.
Thank you.
Edwards.